Okay, I think we're going to call this meeting to order. All right, before we begin, does anyone have a disclosure of pecuniary interest to declare? Seeing none, we'll move on to the adoption of the previous minutes, that the minutes dated June 24th, 2025 of the Short-Term Rental Committee be adopted as circulated. Do I have a mover and a seconder for that motion? Anita and Ian, thanks for raising your hand, Ian. Any, but you've read them. They look right to you. Is there any questions or comments on those minutes? All in favor of that motion? Motion carries. Moving on to item 4.1. How do you think we should go about looking at this, Florence?
Well, I think maybe if there's first any comments from any of the members about the draft that's in front of you, and then we'll go from there. I did, just as a point, I did receive some notes from Mr. Nicholas, which I appreciated very much. So I have them in print as well, so I don't have to go through the recording to to go through those pieces, but some notable edits as well. So anyway.
Okay, before we move on to those comments, then we'll take comments from here. And Anita, first you.
I was wondering more from a clerical nature, not so much the meat and the meat of the draft bylaw. So for an example, on page 5 of 16, it says administration, and then it says, 4.1. And I wondered if, like, under all of those headings of whatever it is, administration, occupancy, general regulations, that sort of thing. It starts with like 1. I'm just gonna find page 5 of 6 because that was my first example. Administration. So under it says 4, and then 4.1, it goes on to talk about this bylaw is assigned to the manager who generally performs, and it ends with without limitation may, and then it lists. I wondered from a clerical point of view, if there is solid reasoning why it should start at 4.1, or should it be 4, just 4, like, and then start the sentence, the administration of this bylaw, ending without limitation may, and then start 4.1, receive and process, 4.2, issue short-term rental, that sort of thing. Do you follow what I'm saying, Florence? I wondered if there's a reason clerically.
No, I think from an administrative perspective, I struggle with this with every bylaw and rule because everyone's a little bit different. So I aim for consistency, but I don't always get that. Ideally, the point of having numbers in a certain order is from an enforcement perspective and from a fine perspective that you reference, especially when you go to the Ministry of Attorney General to get approval for fines, if it has to reference a certain section and the number has to be accordingly. I mean, I'm happy to move it. So like the way it should be then is instead of it 4.1, that stays the same, but then it's 4.1.1, 4.1.2, 4.1.3. So, I mean, in some spaces, I didn't even put numbers because it was just a general statement versus like an actual piece of a rule kind of thing. In that one, the bylaw is assigned to the manager. So in 4.1, it says that's what that's supposed to be. So I'm happy to move that in and created a 3 number instead of a 2.
Yeah, I don't have a problem with
Yeah.
it. I just thought there must be a clerical explanation for it. I just thought that, as you said, sort of a broad statement underneath the title of that portion of the bylaw, the purpose of that statement should indicate what that encompasses. So I don't know if anybody else had feelings about that. I'm kind of a grammar and spelling nerd.
Yeah.
So I like things kind of grammatically correct and spelling grammatically correct.
It's like rhinoceros or rhinoceros.
Yes. But I'd be open to anybody else's thoughts.
I have thoughts. First of all, I think whenever lawyers write stuff, I'm like, oh, for God's sakes, just say what you mean. Why do we have to go through all this jibber jabber? Not that it's jibber jabber, but sometimes it feels like all that really over explaining stuff. But I think when it comes down to so that there's no legal loopholes or whatever, that you do it in this really, I find, onerous way of reading. And, I totally understand your point because that's how I would write it. But I don't have any problem with it being the way it is either. Like, I think it's an onerous way to do it, but that is the way it seems to be done.
So when it comes to bylaws and especially long worded ones that don't have schedules, like this one is where the wording of the bylaw is inherent. As opposed to having a bylaw that says, whereas we agree that we're going to adopt this policy, and then you have a policy attached with a bunch of verbiage. This is, the whole point of numbering everything is so that when it comes to bylaw enforcement, you can focus on, well, as per section 4.2.8, this is what the rule is. As opposed to being like, well, I think it's somewhere in page 8, paragraph 3, sentence 2, right? And when we submit for provincial offenses fines, they want a section and a number. So, yeah.
I should that's a very good explanation.
Okay, then does anyone have any comment about the actual meat? We have Mike's comments. Do we have any others? Sean?
Thank you. First of all, I'm going to say that it is a very good document. It's well put together. A couple of comments that I had was 14.6. It says that the demerit points shall stay in place.
Just hold on a minute, Sean, while we all get to it. Okay, 14.6, you said?
Yep, it's on page 15 of 21.
Okay, go ahead.
It notes that the demerit points will stay in place for a period of 2 years from the anniversary of the date on which the demerit points were assessed. And I'm wondering about that timeline, if it's a 1-year license program. Does that encourage folks to, when they renew their license in a subsequent year, change who the registered name is or something like that to try to circumvent the demerit points? I wonder if it might just be simpler if it's a 1 year. Just a comment. And then with on the following page, the column 1 infraction, I noticed that it's upon conviction of an offense. And I wondered if there was any way that the demerit points could be applied without a conviction. If it was say an unresolved complaint. So if the neighbor called the responsible person and they weren't able to resolve the complaint, could we still apply the demerit points without a conviction? And then
Hold on a sec. Do you have an answer to that before he goes on?
I think it's completely possible. If the bylaw says that, you're going to get a demerit point with a complaint that's substantiated, like where there's maybe not convicted, but, or convicted sounds so harsh.
Yeah.
But I mean, it is like, if you have a demerit point that could be issued, even though we're not it hasn't been confirmed or proven necessarily. I'll see about a way of wording that in.
Yeah, I just wonder if it would make it easier to enforce and that you could implement the demerit points. They could still go through the appeals process for that, but it's a lot less time consuming for staff than getting an actual conviction through a Part 3 summons. And then one other really small item in the appendix, Schedule A, item 6.
Hey, hang on 1 second.
Okay. Page 19 of 21. It refers to number 6 refers to obstruct an inspection of a premises, and it references 3.3.4. 16.2 also talks to inspection of a premises by the manager, designate, or whatever. I wonder if 16.2 should be added in there.
Agreed. Thank you.
And then if you look at the item numbering on the side.
Yeah, I took one out. Sorry.
All right.
There comes a point when you're looking at this for as long as you do, you just stop seeing things anymore.
Great catch there. Anyone else have comments? Anita?
Thank you, Madam Chair. I agree with Sean. It's a really good document. I think it's very extensive and I appreciate all the time and effort that went into it. On 5.1, I'm not sure what page that is.
Registration requirements.
Yes. There's talk on 5.4 of the proof of age. It says if the applicant is an individual, proof that the applicant is at least 18 years of age. I'm not sure. I know if the applicant could be like the son of somebody, right, that owns the place, and maybe the son is 17. It's not the owner, it's the applicant, right? Theoretically, it could be. I just wondered, I guess I got thinking, if you own a premises, you're probably over the age of 18. I mean, that's a presumption, I know, but I didn't know if that was necessary to have proof of age.
I guess that's up to the committee to whether or not you want to include that.
Yeah.
I have a question. Is it standard? Like,
That line has been in all of the bylaws I've
Yeah.
looked at.
Has it?
So
Okay.
that's kind of,
Okay.
and maybe people register it in their kids' names to get out of something. I don't know.
And may I
Yep.
continue? Also in section 5, the next page, 5.6.2, it talks about the proof of a corporation. And it says a copy of the corporation's most recent corporate profile report. I wondered if we would consider making that, instead of a recent corporate profile report, maybe a CRA document that has a business ID number associated with it, for example, workers' comp or source deductions or something, as opposed to the corporate profile report. Only because it'd be pretty handy to, grab your source deductions remittance form that has your business number on it. Or is that too onerous to ask for the corporate profile?
so I did look into this back when we talked about it originally. I'm gonna have to do a bit of a search of my
Yeah.
stuff here. Continue on and I can
Okay,
have a look at that.
okay.
Well, I'd just like to mention that the second half of that is a declaration signed by an authorized officer of the corporation confirming the names and contact numbers. Like, that's really, really simple to do.
So
like
more of
the
an
second-
attestation and.
Yeah.
Yeah.
Yeah, that'd be really simple for our corporation to do.
So I wonder if we could make it something.
Well, I
Easy.
don't think that either one of them is hard to get, like
Okay.
had to supply those for grants or whatever. They're really simple
Okay,
little thingies. They
Okay.
are. I don't know why they ask from them, but they do.
okay.
And then sometimes they say, your most recent within 2 years, CRA something,
Mhm.
but that's usually something you have to ask the accountant for, which adds the fee. And it's like, can't we just do this other one instead? Like the
Oh.
CRA one's not as easy because they get kind of specific, because they if it's not within the last year, then it's not relevant. And so your accountant has to send it to you. At least that's
Okay,
been my
I was
experience.
thinking of, my remittance forms for source deductions or
Mm.
workers' comp or something. I submit those every so many months, right? So I have copies of them all the time, but I'm okay with that. But when I said the word attestation, I like that word. In 5.19, there is a sworn declaration from each applicant and owner and tenant acknowledging and confirming. So a sworn declaration,
Sorry, but where are you?
oh,
Which one?
5.1.9, just a little further down the page.
5.19.
Oh,
5.19, yeah, that's why I
sorry,
couldn't find
sorry.
it. Okay,
Yeah,
thank
yeah,
you. Sorry, go ahead.
Page 11 of 21, a sworn declaration. Is that considered an attestation then, or if we switch that wording? A sworn declaration, what would that look like? Would you need to have a notary public or something to authorize a sworn declaration? It just is a handwritten.
I think it would just be, sorry, I just turned off, didn't I?
Yeah.
To me, that would be something that would just be witnessed.
Okay, okay,
Okay. Yeah. So I'm just going back. I did find where I did get some clarification on the purpose of asking for, and this was originally in the original draft of that particular section, that line about the corporations said, what would be the purpose of providing a certified copy of the most recent Canada Business Corporations Act annual return? And pretty much it confirms who owns and controls the corporation that is applying for the short-term rental license. And it also ensures transparency, particularly where corporate entities, as opposed to individuals, are the registered property owners. So it basically says, that we put a face to a name. And so it has, or at least a name to a corporation. So that it isn't just the corporation applying for it. We have a list of who actually owns that corporation.
Okay.
So it's, yeah.
Just in regards, I have a question about that as well.
Yeah.
Is that what if a family owns like a big family owns, like
Yeah.
there's more than one person or two people? Does everybody have to be included?
Ideally, yes. It's the same as what's on
There'd be a president of the corporation, wouldn't there?
no, I think what Mary's referring to is if there's a list of 3 or 4 people who own a property. So what we would refer to, and I think we talked about this on the application form, is we would kind of vet who owns the property based on who's on the tax roll. Right?
And like, for example, our corporation, there are 5 directors and they have specific signing authorities. So like while our bookkeeper pays the bills, she does not have the authority to do something like this, right? It has to be one of the listed names. So we have a piece of paper saying that. That's all, just making sure the right person's doing it, I think.
I wonder if it should be made a little clearer in the bylaw then? Or do you think that the clarity of that is sufficient, the way it's written?
So the way it's written is a copy of the corporation's most recent corporate profile report or a signed declaration by an authorized officer of the corporation confirming the names and contact information of all individuals with a controlling interest in the corporation. So I think that would satisfy it.
I think so. And I think that people who are actually actively in the corporation understand the wordage and they're like, yeah, we do that all the time because you do, right? You have to know who has the authority and who just has interest in it, right? Any more questions, Anita? Are you okay with that?
I've got a few more, but I'll sit on it for a few minutes.
Okay. Does anyone else have any comments before we get to Mike's? Did you see a hand up? Oh, Mary?
A couple of the same comments, but on page 12, 6.1 is about occupancy and so let's see, where is it? Maximum and we talked about this a fair bit actually. Maximum occupancy of 10 persons, but then children under 12. There could be as many children under 12, and I think if 5 couples, with 10 adults and there are 5 couples, and they all bring their kids, that's a baseball team.
That's at least a baseball team. I'd say it's more than a baseball team.
So I don't know how you, I don't know if you want to quantify that. Like, I'm not sure. Certainly as a short-term rental owner, like we'll have a couple of families come and they'll bring their kids. But if you've got 10 adults and they all bring their kids, that's a different thing in terms of usage of the property and also, the impact on neighbors.
So are you suggesting like perhaps the age should be younger? Because 10 6-year-olds, although a pain, are not much of an impact as 10-year-olds or 12-year-olds, right?
It's debatable.
Or like, well, yeah, I have an adventure team. I don't know why I said that. I mean, I was thinking the toilet. But the other thing is and I don't disagree with your comments, let me say that, but who's going and policing that? Like, like if we're going to say so many small children and they all look the same to me.
Well, it comes back to the demerit points. If this becomes a recurring issue and it becomes a complaint issue, and then you go back and we get the records of, yes, you had 10 adults and each of them had 6, 8 kids, and you're doing this on a regular basis, well, then it should exceed occupancy. So, I mean, again, we have to hone in on the rules are in place to kind of prevent it from getting out of hand, knowing well that it will periodically, right?
Right.
I mean, most people don't have 6 kids now anyway, each, I think 3 is probably the max, but.
Yeah, okay. So just because I've seen several hands up, we're gonna go to Mary, then Mike, you're still awake and we appreciate that. We're gonna do you next, and then Evan, and then Ian, okay? And if I forget that, go ahead and remind me. Mary?
I just wonder about maximum occupancy as 10. And not even mentioning kids, I don't know.
I like what you're saying there, because like if it was us, they'd be like, well, there's 10 of us, but we also have, 4 little kids. Is that okay? Like then they ask you and you're aware and whatever. But you're right. If you say 10, well, we can all bring our kids, then now you've got, easily 30 people using one toilet or whatever it is, or, so I think that gives you the leeway as a property owner to be aware of what's happening without, having a hard no, or having someone having to count little kids, really. I don't disagree with you, Mary. What do you?
An example, last week we had a family come in and they were lovely, and I think they registered as six adults, and each of them brought 2 or 3 kids, or each couple brought 2 or 3 kids, and it was fine. We've got a big beach, it's quiet, but if they weren't, it would have had a big impact, or it could have had a big impact on the neighbors. That's all.
Would the solution be to bring the age down? Is that I'm just trying to figure out how we would put that in writing. Like, you know what I mean? Like, how do you?
I guess one of the things that I would think is, as Jennifer mentioned, is that leave it up to the discretion of, like, if you just have the number 10, and then you got to have a conversation with your renters, and you're going to ask how many people, and how you're going to discuss what the capacity of the building is. So I think most people would let you know if they're going to bring a baseball team, right?
Yeah, I don't think that's like, if you go in a hotel, then like, how many adults? Do you have any kids? Like have a conversation before we give you the room type deal. And of course, everybody says one kid and brings in the ball team and they sleep on the floor, but at least they've asked the question.
That's a hockey team.
It's actually a broom ball team, but okay. Does anyone else have any comments about this specific issue before we go into the round of it? Oh, everybody wants to talk about the occupancy. Okay, we're going to talk about the occupancy. That's going to go Ian, then Evan, then Anita.
I think this is a good guideline, and it's up to the owner to set their own policy for their building. So if you don't want 3 kids per person, then you can set that policy yourself, or we can set it ourselves. But I agree with this policy to start with.
Evan?
When I read this, it kind of made the example of, say, a cottage with a mom and dad and 4 kids, and you have grandma, grandpa come one afternoon for supper with another aunt and uncle with some cousins. That would allow that event to happen with the 10 occupants. If the 12 and under don't count, that would allow grandma, grandpa, and a brother and sister-in-law on the back deck for the afternoon. So when I seen that kind of incorporated the day use, I guess, is how I seen it. I wasn't thinking that 5 couples would come and cram into 5 bedrooms and kids. So I like that in there just because it kind of allowed the flexibility of the day use with other family members to come.
Anita?
Well, as everyone knows, the occupancy has been sort of a sticking point with me, but I agree with everything that everybody said. But my comment on this is, I wonder if, because it's so crucial, that we could break it down into 2 sentences. Again, it's clerical, and The maximum occupancy permitted in the STR shall be determined by reference to the number of bedrooms in the STR, period. The maximum occupancy shall not exceed 2 persons. Just so that one sentence doesn't flow into the other and you kind of get lost in the weeds in that part of the bylaw.
Does anyone else have a comment on that specific portion? I will say that my son's getting married in 2 days and I have people using short-term rentals right now. And my sister is staying at one in Port Albert that sleeps 6. And she reached out to the owner and said, is my sister, me, and their family, am I allowed to have them come and visit? She goes, because a lot of places they say you can't. So I'm asking before because I don't want to get in trouble. I'm like, well, good for you. We have no rules, but I won't tell you that. But so, and she, like they're from the States, they go all over that she wanted to make sure that other people were allowed to visit because so many people don't let you visit. So I like the fact that, I like the fact that it allows those gathering and it's clear to them because my sister said, I'm not inviting you over till I get a response from the owner. And I'm like, okay, that's fine. I don't have time anyway, but but I do think I think we're talking about doing a review in a year that maybe this is one that we flag and make sure that we remember to look and say, how did that work? Should we have made it a little different? Is everybody okay with moving on from that? Oh, good. Mike's your hands up because you're up next. You look very wide awake.
I'd still like to weigh in on this guest issue
Yeah.
because the occupancy limit, I think the way we've defined it, yes, it's driven by the number of bedrooms and we're going to establish it by the number of guests. But guests, by the way we have defined it, does not include any daytime visitors. It's only the ones that are staying overnight.
Mm-hmm.
That's our definition, 1.10 on page 8 of the bylaws. I think it was page 8.
That's a great point, Mike. We're all looking for it right now. So hold on a second.
What was the number again, Mike?
Section
1.10?
1.10.
Okay.
Might I suggest that under 6.2, it be reworded to say that guests are permitted during the daytime, something to that extent. And they may stay overnight provided that the occupancy is not exceeded. Is that kind of where I'm hearing this?
Like something along like daytime guests are permitted, but no.
Like acknowledging the daytime aspect of it versus the nighttime, right? Acknowledging that the intention of having guests is to come for the day, whereas they might stay overnight, but for the most part, the intention is daytime.
Does that seem reasonable? Okay, Mary.
Isn't that what 6.2 says?
But we don't mention nighttime. So, but guests, like in the definition of guests, a guest is an individual who is not a renter, but is temporarily visiting the STR premises at the invitation of the renter. Guests are permitted to stay overnight, provided the maximum occupancy is not exceeded. So by virtue of that, I guess that is addressed. I mean, this is a nuance to me that would really be picked at if we had some issues again. I guess I'm just looking, is this something we need to change or is it seem to be addressed?
From what I'm hearing is, from a clerical standpoint, you feel it's been addressed, but we should maybe monitor it.
Or just articulate it a little better?
Anita?
Well, that would mean perhaps opening another definition as far as visitors to the STR.
That's exactly where I was going. I was going to say, do we need a definition for guest and a definition for overnight guest? 2 separate definitions.
One's a visitor and one's a guest.
Yep.
Yeah.
I thought I saw it too, actually, which is why a word has popped in my mouth.
I thought
Mary?
there that we sort of had sorted this out is that the occupants are like there's the occupancy, 10 people or whatever it is, or children. And so they're the renters, right? And the guests are the people that come for the hot dogs and the beer, right? So do you have to do you have to put visitor in there? I don't know.
Yeah, again, I think it's if we stay silent on the matter, guests are the ones that stay overnight. Whoever else shows up during the day, fill your boots.
Yeah, that's it. We're only making sure that guests are included as part of the occupancy at night. Like otherwise, again, fill your boots. Like if you want to have the birthday party and your landlord, for lack of a better word, says that it's okay to have the birthday party in the afternoon, so be it. But as long as at nighttime, your occupancy does not exceed the 10, however that ends up.
Yeah, because we talked about Mark's birthday party.
I was going to reference it, but I
That's
thought he was
probably
not here.
where he is now. He's at his birthday party and we're not invited. Thanks, Mark. He'll be going over these minutes later. I know. Do you want to go over Mike's notes, or does Mike want to go over Mike's notes?
Maybe we'll
I
let
have a
Mike go
question.
over Mike's notes.
Sorry,
Oh.
I have a question first.
Yep.
Florence, were those notes or my text notes on the bylaw, were they distributed to anybody? Or do I have to
No,
go through it?
I did not. I kept them to
Okay.
myself.
Okay. So my apologies for boring you all with this. Let's go back, scroll back to the top here. I'll refer to the page numbers where I made some of these editorial amendments. I'm starting on page 8 of 21. This is a minor editorial thing. 1.18. Owner means a person or persons. We define person, so those should be both capital P's. That's an easy one.
Great, carry on.
Next is page 10. Well, actually, let me refer you to the bottom of page 9, first of all. 3.1, it starts out by saying no person shall advertise. And then if you go to 3.2, it says no person shall market. For the sake of consistency, I think we should be using advertise in both cases.
Agreed.
Okay, great, carry on.
Sorry, my computer's a little slow. Sorry, the operator is a little slow on scrolling. Next, I'm on section 9, which is page 13. The title of that is refusal, revocation, and term of registration. But if you read most of the bullet points, they deal with the issues of reviewing the application, refusal, or revocation. And the issue of the term of license is actually on the next page, number 10.
Mhm.
So my suggestion was we just change the title of that one to read review, refusal, and revocation of registration.
Great catch. Carry on.
Now I am on page 14, section 11.2. The second line states that if there is any immediate danger to the health or safety of any, it says person, but the way we have defined person is the renter, sorry, a person is the owner, the licensee, the responsible person. I think the word person should be replaced with renter or guest. Because that's
Makes
who we're
sense.
dealing with.
Yep.
Somebody that's actually visiting the premises.
We agree with that. Yep. Okay, Florence. Florence says yes too. That's great. Carry on.
Section 12, throughout that section, we use the term owner. Is it more appropriate to use the defined term of applicant rather than owner in this section? Because the applicant, who ultimately will be the licensee, could be an owner, it could be an agent, or it could be a tenant.
Great point.
And
I'm very good at it. Very good. I'm so grateful he's
sorry,
here.
there's Florence, again, there was a couple here which I didn't pick up the first reading of this thing. This is maybe a nothing, but on page 16, where we list the various bylaws that could lead to an infraction, specifically items 4, 5, and 6. Is there any merit in actually specifying the ACW bylaw number?
Yes, I think there is in there because there is a clause later that talks about any legislation or whatever that's referred to would be considered the most up to date. So that's number 19, refers to the references in the bylaw.
Okay,
So I think
okay.
it's worth, yeah, I'll add in the bylaw numbers.
Okay. And my very last item is Schedule B. And again, the word owners appears throughout Schedule B.
Okay.
But once again, I think we're dealing with the licensee as opposed to the owner, because it's the licensee that ultimately holds the license. Now, there's one
Okay, now,
exception.
are we talking applicant or licensee? Because we just
No,
switched terms
licensee.
there.
I
Will
think
be licensee by
licensee.
this point.
Yep.
Okay.
Yes.
The only one area where it could be someone other than the licensee, and that's on page 21. And that would be just before the declaration. So the line, there's the line that says I and there's a blank. Well, the line above that, where it, if any of the alarms are not operational, the renter shall immediately notify the, and my suggestion there is we take out owner and put in licensee or the responsible person, because we've created that class of who's going to get reports if there's a problem. So it's not only the licensee that should be notified if they're available, but certainly that's a role of the responsible person as well.
Yeah.
Yeah, I agree.
Okay, thank you, Mike.
And I actually, since we were talking about guests, I noticed that we use the term guest somewhere in here. This is again Schedule B up to paragraph 5. The second last line, the maximum number of guests permitted,
Yep. Capital
capital
G.
G. Yeah.
I swear, when we're done, we're going to have the best authored bylaw in all of the province. Thanks, Mike.
Okay. Does anyone else have any more? We all hate to go after you, Mike. Oh, but Anita's taking a shot. Go ahead, Anita.
Number 13, and I'm sorry, I don't have the page number, but I'll have this there.
The order?
The title order. I wondered if there was an alternate name other than order. I put down contravention and direction, but I don't know if I was taking it from further down. I don't know if order sums up what you're trying to say there, the word order.
Mm-hmm.
Yeah, I get your point, Anita, but nothing else is coming to mind.
So usually when the municipality issues an order, it becomes a legal document that tells the the person who's contravening, that they are contravening. It usually lists when the enforcement officer was there. It lists all the details and usually has a date for compliance, so to speak. So I think from an enforcement perspective, I think we'd prefer if it was kept at an order because it does have a bit of a weight to it as well. Yeah.
It doesn't actually look like a weight, or does it need to be capital? Because served in order, you could be fries. I mean, if you're not, you don't know what the vernacular is, like an order of what?
What I was
You know?
getting, I haven't gotten to it yet, but back in the descriptions, do we have order in?
Definitions, no, we don't, no.
I wondered if that
An
would solve
order?
the problem,
Definition of an order?
the definition of order.
Yeah, because
And then it says in the second sentence, the manager may serve an order, then that should be capitalized as well then, if that's the case.
What's that?
Yeah.
Yeah, and I think that's a good point because it was very clear to Florence it has weight, and I thought of French fries because I was hungry. So I mean, we have to make it pretty clear what an order is.
Yes, and then going on to 14. You say we've got to figure out what I wondered, did we talk about a warning system? So similar, I think Jennifer, you were mentioning this, if you've had a driving infraction, the Department of Transportation is going to send you a warning saying like, you know what, you're close to your points. Did we talk about that? That is there a warning, or is that possible to have that mechanism, staffing wise, to have that you're approaching a point where your license is maybe suspended?
So to be clear, what I actually said, what I had some personal understanding, though it wasn't me, you do get a letter, but it says, let's come down and talk about it. They don't tell you, they say, yeah, you're about to lose your license and you should come tell us why we're not going to take it away from you. So it's not just they're warning you, it's the first step of a fine, right? Like it's not really a fine, but if you don't convince them.
That was the
Yeah.
example I was recalling
Yeah.
when I was reading this. And I thought we talked about that, but I don't know where we landed on it.
Yeah.
And I don't know if there's a mechanism in place staffing wise to be able to do that. Or should we do it? Or because the suspension is like 6 months. So that could take out your whole summer, right? If you had so many infractions by April 30th, your whole summer is gone. Your whole rental season is gone.
Yeah, I if I could jump in, and I can because I'm the chair, I'm going to let me. The issue I see with that is that we're going back to the stick, which is not maybe the right way to do this either, right? So could we maybe do something more of, I don't know, for lack of a better word, a report card at the end of the year, say, hey, you didn't get any demerit points, you got a silver star on our little chart, and you're about to use your license. You know what I mean? Like more often or something like that. I think that people doing it well should also, if we're going to be babysitting the ones who aren't doing it well, we should be telling the people who are doing it well, or publishing a report that, you know what, 95% of the people are doing it great, keep it up, people, or something like that. I'm just thinking as I'm sitting, and that's usually not a good thing.
I see where you're going, and I would see and I hope that this committee meets, in a year after the bylaw is sent to council to review it, tweak it, refine it if necessary. But I'm hopeful that there would be some kind of report at that point that indicates, this is how many people were and had infractions and what level of infractions they had. I don't know that I like the idea of a report card that goes to each of the STR applicant owners. I guess I go back to that we had discussed that this should have an educational component to it, as opposed to a penal kind of way of handling it. It's just something I thought of, and it should be discussed, but I'm okay either way.
Mary?
Just have it's not particularly about this, but it's Blue Water has a demerit points, right? And do we know how that's going for them? like I would be really interested to, like, I know that they were having a hard time enforcing, you know, getting the evidence, in court. And so that was, you know, that was a difficulty for them. But I just wonder how Blue Water is experiencing the demerit point system.
I would have to ask. I did, back in the spring, I asked them for a little bit of information and I didn't get a response, necessarily from them. We can definitely look into that. In terms of, and just a couple comments, and I think the conversation went a couple of different ways, but in terms of a demerit point system and how staff were to execute that, I think that's more of an internal process and procedure. I don't think it's necessary to articulate that in the bylaw itself. Because otherwise this thing, like if we really went at it, like this would be 30 pages long. So I think there's certain aspects, as long as we know that there's a demerit point system in place, they would, you know, the way even orders work, we don't throw an order on someone at first instance. Normally you go and you have a conversation with them, you give them a timeline, you have because compliance is what you're looking after. It's not necessarily, it's when the compliance is not happening, that's when you go in. So owners would be aware of what's coming at them. So again, same with, you know, if we were to issue letters, it would likely say, you know, you already have 4 demerit points, this would be 7, another 5, and you lose your license, kind of thing. From an administrative standpoint. I think that's my comments for now.
Makes sense. Anybody else? I have one comment, and I'm not even sure if it's a comment or question. It's item 14.6, where we mentioned the demerit point shall remain in place until the 2-year anniversary, and we're going to change to the 1-year anniversary. My question is of the date on which the demerit points were assessed, because we talked about assessment as opposed to conviction, and then like, what do we see the time frame of them being assessed is? Like, if they do it in July and then we have to do due diligence and then they get assessed in September or something, like, should it be from the date of the infraction as opposed to by the time we got paperwork done? You know, because I have no idea what kind of turnaround this is. Ian?
Could it be for calendar year?
I think we can be whatever we do, but I mean, yeah. Yeah, I think they're, per calendar year. I don't know. Florence, what do you think?
I mean, to me, if it's the end of the season, like if it's the end of the season and it's September 30th and you got your first demerit points and then they wiped clean at December 31st, I don't think that's, I don't know, I think some people are getting off a little easier because of the time of year that it happens, which I'm not sure that.
The other thing is, if you've gone all year without one, chances are you're not a bad apple anyways.
Well,
So
fair enough, but
Yeah, the milk board gives you assessment or demerit. They don't give them to us, they give them to the bad people, but you know, you get so many in so many months. It's rolling, right? It's not per year. So if you really mess up, it's not the calendar year. You get 6 months to fix it or whatever. I don't know. I'm not intimately acquainted with that, but I know it's not calendar. Florence.
I was just even looking at it. I don't like the word assessed. I was thinking of the word issued.
Yeah. I think that's kind of what I was struggling with.
So an issued to me is when the enforcement officer comes in and says, hey, this is a problem issue. Like, we're going to have to issue them a letter. It's July 29th. That's the date that they're being notified. They'll have a letter sent out to them, you know, effective July 29th. You have 4 demerit points. This will stay on your file for a whole year.
Sorry, does everyone kind of agree with that? Show of hands if we kind of agree with that? Yeah, okay.
Thank you.
Are we done with this? Sorry, are we done with this section? Are we? I guess should the draft be acceptable? Is the draft with the amendments acceptable? Show of hands? And Mike, it's unanimous.
Okay.
All right, then we'll move on to 4 point.
Sorry, I would just like to talk about that next step on that process here.
Yep.
Sorry.
I don't
Sorry,
know.
Mary, go
I
ahead.
don't know if I agreed about the acceptable.
Oh,
I
okay,
wanted to have
sorry.
a little bit of a discussion with.
Sure, sorry about
um,
that.
If that's okay. On reading this, I think it's a good document. But as a short-term rental owner,
Mhm.
I was pretty overwhelmed by how the hell am I going to do this? You know, how am I going to implement it? And like we only rent 10 weeks of the year, right? And so it seems like a lot of work.
Mhm.
And I wonder if it could be a little more user friendly. And I know it's a legal document, but somehow if you're going to if we're going to implement this, right, or the municipality is, I think it has to be palatable for people. And it is, and I know it's a legal document and
Right.
all that stuff, but could it be a little easier? You know, I think on what page was it? Page 9, I really, the statement of intent, I really like the minimal interference by the municipality. Like, and that's what I think this committee's looking at and what the municipality, but then you go to the document and, you know, I have to get a legal, you know, for my 10 tenants every year, they have to, who've been coming for years, you know, have to sign a document or, you know, like a code of conduct. And then I have to keep it for a year, you know, and so, I'm probably gonna, you know, if that happens, you know, I'll do it, but it's pretty overwhelming. It's, and so I just wanted to share you know, my thoughts about that as a short-term rental owner.
Lawrence?
So I think it goes without saying that this is going to be a change implemented for a segment of our community for sure. And that's the whole reason why everybody's sitting around this table today is to get it kind of right in a certain way, find that balance so that when it is presented to the public, that it's done well. It balances the interest of the owners and the expectation of the municipality. But it also, those people in this room, when people ask questions, everybody can answer the questions. The document that is prepared and to be presented to council, it's literally the meat and potatoes of what the content of the regulation is. Again, legal document, as you've mentioned, and we have to, if we want to enforce rules, this is the format in which we have to, at least at the bottom of it, have this prepared this way. Stated, I think it's, as you've mentioned, it would be palatable to have, as part of the education piece, a package that kind of narrows out, you know, this is what it's going to mean. So as part of the process moving forward, go to council, say, these are the rules that we're hoping to, or that the committee has kind of agreed are acceptable to most everyone on the committee. And then from there, we're going to go and we're going to have a public consultation process. That public consultation process will give us the pros and cons of what has been presented. There may be a few items that we haven't even considered that are issues. And then we'll kind of take that back as a group and say, here are the most common themes of what's been presented, and then narrow it in from there. But as part of that is have that education piece in response to those queries and issues from the public to have back to council, so that it isn't just the black and white piece of paper document. It's also, as you say, like, in order to get a license, here are a few quick checks that are the bulk of what you need, that are outside of what you would probably normally do. But I completely appreciate the comments. I'm, you know, from a staff perspective, this is a big project, not just in preparation of doing this, but also moving forward. And it's not something that, you know, necessarily asking to do. But we recognize that it's something that we're tasked to do, and trying to do it in the best way that we can. And I think having this committee here has probably been one of the more beneficial things of this process thus far. Having the input of, you know, STR owners right now is crucial too. Anyway, I'm digressing. So
Got that song in my head. Carry on, carry on. Okay.
Jennifer.
Oh, sorry, Ian, yes?
Is there any chance of having a layman's copy of this rather than a
Layman
legal?
copy. Yes, that's a wonderful way to describe that. Layman's copy. Yep.
Because I agree, like it's very onerous and I bet you there's 50% of the people will not apply because if they see this document,
Mhm.
even see a layman's copy for a season that's 12 weeks,
Mhm.
16 weeks long, that they ran it out for 3 months to cover some of our ACW taxes that we can't, like in our association, we only use our cottage for 4 months of the year. So we're paying the same tax as somebody up on top of the hill gets their road plowed and their garbage picked up and their recycling picked up and year round. So and their trees picked up when the hurricanes go through and which we didn't get any of that. So we're paying the same tax as somebody else. And I know there's guys in our association will look at that and say, not a chance in hell I'm going to do that. That never advertise either. So because they're again, I'm going back to my comment earlier that these guys are renting out to neighbors and co-workers and friends. So legal live. Yeah, I wouldn't expect them to go through the work, but that's me.
Florence, you have a comment?
Just the whole purpose of going through this is for the issue, it's for the problem areas. It's where the complaints are. If there are communities where there are no complaints, then it's never going to get enforced. Like there's no, right? Like that's not the issue. The issue is, well, so-and-so's got parties every weekend. They clearly have the occupancy. They don't have a license. You have to get a license. Again, everything that we do in the township is complaint driven. It's complaint driven. So there will be, but there's no doubt, like I have no doubt, there will be those that choose not to do it. They fly under the radar. So be it. If 5 years down the road, your neighbor decides that they don't like that, they'll start complaining and then you would be subject to the bylaw. But that's just the nature of how our system works.
Yep, Mary?
Just, I'm curious, we're halfway through the summer. How many complaints have been made this summer? Do you know?
Yeah, we do know, we track them every month. Yeah, while she's looking up, I'll say, I agree with you, Ian, and that's kind of what I said was these lawyers give you papers and you're like, can you just tell me what this means? Because they're just overwhelming I know they have to be written that way, but really for the rest of us, what does it say, right? I get lost in the whereases and the heretofores.
Sorry, without super confirming, it's probably about 10 to 12.
Are they the same, from the same area?
They're probably about 6 different properties, maybe.
Yeah, Ian?
Same properties as last year.
It's always the same properties.
So we're doing all this for 6 or 7 properties, and I'm sure they're all commercial properties that do it.
I can't confirm whether they are not, but yes.
Yeah, we are, but I would add that council's been hearing about this for a long time and most of it's happened post-COVID. So all the neighbors that you have now that are, don't rent out, that doesn't mean in 10 years that one of them won't sell out and then there's a big problem and the other neighbors are not going to like that. And that's what's happened in these other areas, right? We have to plan for the future as well, based on what we're seeing is coming and we're seeing this is coming. And we've been hearing about it, particularly since COVID. And lots of complaints about the beaches and everything post-COVID and yeah.
If I could add a comment to Ian's, yeah, the challenge, and it's a balancing act because we're having to do this. You could count them on one hand. And, we need to have something in place to deal with that one hand without the total expense of all the rest that are well-intentioned and not creating a problem. It's a balancing act. You're absolutely right.
All right, did you want to talk more about the process before we went on to 4.2? Okay,
Microphone.
Can I jump
Um,
in for a second?
Yep, the mic.
sorry,
Go to
Mike.
the subject? Yeah, and certainly I think the amount of time and effort that has gone into crafting this document is important because it ultimately has to be, withstand, I guess, legal scrutiny if you're going to go, try to enforce something with the 5 or 6 bad apples that are out there. And, maybe that's a number that's going to increase over time if that's a developing trend. So without having something that is as detailed as this bylaw is, you won't have the ability, to enforce anything. So I think the time and effort spent on developing this has been a good effort. But I also try to look at it from the perspective of what challenges does this present to the casual renter. Some may choose to fly under the radar, as was suggested, and probably not a problem because they're not the ones generating the complaint. The commitment in time to go through that application is fairly onerous. A lot of that stuff, though, you have to do once. You do your site plan, you do your parking management plan, you come up with a waste disposal plan. The 2 areas that are going to be particularly challenging, in my opinion, for the casual renter is finding a designated responsible person that they can put on file, and also, I guess, an alternate responsible person. And not to be overlooked, the casual renter might also be surprised if they go to their insurance company and say, I need a document that confirms $2 million liability. That's not the problem. But, oh, by the way, I needed to mention the fact that I'm running a short-term rental for, a few weeks out of the summer. Some insurance companies are going to have kittens over that. So I think, I think it was on the agenda for today as far as, do we have to spend some time thinking about what exemptions we work into the system? And I'm sure we're going to hear, when we go through the public forum discussion, we're going to hear more about that as well. Just as, as Mary suggested too, if you're only doing it, a few times during the summer, so many weeks, then, you don't want to suggest people fly under the radar, but it's reality. That's going to happen.
Anita.
If I could chime in too on Ian's concerns, and they're valid concerns. I think it's important to note too that we've tried going through the route of the provincial government doing this, and they're hands off. They don't want anything to do with this. So they've left this dirty work up to the municipalities to do. And other municipalities, you can see, are doing it, particularly along the lakeshore. And not only to address the handful of nuisance STRs that we have, but it will, as more and more municipalities enforce this through a bylaw, and we don't, it's my suspicion, word will get out there. ACW doesn't have any rules. And it just has a potential for increasing. And then if it gets to the point where it's so bad, then it becomes really onerous. If you think it's onerous now, it becomes very onerous after that. At least at this point, we're talking, I think we're sort of sidelining exemptions here. And I think that's understandable and possibly a way to, go about this bylaw, but I don't see how ACW can move forward without this bylaw.
Yeah, I want to add to that because I've been getting a lot of complaints about Ashfield-Colborne-Wawanosh beaches now that there's paid parking in Goderich. They all come to Port Albert in that, right? I mean, it just, and it's all been since COVID and everybody found us, and change is a coming and we have to be ahead of the change. We took a couple of years of talking about this before we decided to strike this committee too. And I like Mike's comment that you do have to do it, but it's just once, most of it, and then you're kind of protected. Ian, did you want to add to that?
Don't get me wrong, I do not disagree with the process. I do not disagree with having it. Our problem is that we've got such a short season where I think almost everybody we looked at that did we looked at their short-term contracts, they have a 12-month season. They can rent for the winter time, they can rent for the summertime. So again, we're just that 12 week or 16-week period. So I walk up down our beach and I bet you there's not a week that half the cottages are up. It's fairly, again, it's a private road, which in a way is a blessing because then we're discouraging people from coming down using our beach. Where Point Clark or some of the other places aren't private. So, but I certainly don't disagree with it. I feel bad for the ones that are doing it for a week, 2 weeks, 3 weeks just to help pay their taxes. But somebody like us that's doing it almost for the full season, then we're on board. We're game to do that. So I don't disagree with it, but I feel bad that we have to pay even if it's $150 fee a year, up to $3,000 a year of fee for a handful of properties. And like you say, it might get worse as time goes on. But that's not today.
Thanks. And I agree with your comments, and we're going to have one more on this, and then I'm going to move it forward. So Glenn, would you like to say something?
Yeah, thank you, Madam Chair. What do we have in place that if an owner is not registered and there's a complaint against them, that they cannot continue until this has been dealt with?
In the bylaw, it says that no person shall operate an STR without a license. And if you don't have a license, you pay the provincial offenses fine, and then you could potentially go to court.
Okay, that's good. Thank you.
Okay, moving on to item 4.2, as previously discussed. Ian was not present at the previous meeting. We were waiting for you to just zoom in from Scotland and saw nothing. Would you like to, we saved it for you, Ian. What would you like to say?
I think I've said most of it already because it's the ones that do it for 2-3 weeks of the year just to help cover the expenses. And most of those guys, I don't think any of them will probably advertise on any kind of website. They do it word of mouth. So whether this could be geared to people that advertise it to Joe Blow, maybe it could be. I don't know if it might not be fair, but we don't have to advertise our cottage any place because we're into it. We're into repeat businesses. We're booked from now till next 5 years until somebody dies. So, and you're probably the same way with your people.
So can we maybe table this one until after our public consultations to see what everyone has to say? Maybe there's some good ideas out there beyond us.
I think that's a good idea.
Okay, everybody okay with waiting till after the public consultation? Okay, great. So let's move on to 4.3. Proposed fee discussion. Hang on, my thing went dead on me again. Oh, well then, I don't have to look at it. How do you want to handle this? You'd like me to call on Anita? Perfect, Anita.
Well, I know that fee has been a topic of discussion, and it's really hard to nail something down that seems fair. In the drafted bylaw, I don't think there's anything that I read that says, as you say, Ian, how many weeks do you plan to? You have to presume it's 52 weeks, right?
Yep.
With this bylaw, but I don't know if I'm just throwing this out because I just thought of it. It's not something I've been thinking about overnight or anything. And it might tie into exemptions. Is there a way to base the fee on the number of weeks that you rent out? So, for example, if you had an exemption, I'm just throwing this out. If you had an exemption in the bylaw that said you only rent out for a total of 6 weeks per year, 2-week maximum intervals with 2-week intervals between the next 2 weeks. If you follow what I'm saying, so they can rent for 2 weeks in June, they can rent for 2 weeks in July, they can rent for 2 weeks in August, and you'd be exempt from the fee of the licensing fee. But if you rent, and the people that the nuisance ones, I think, Florence, correct me if I'm wrong, tend to rent out from about Easter till Thanksgiving every weekend, every week, all the time. So then your fee would be tied to how much you rented out. But then it becomes the applicant or the owner can say, well, I'm only renting for 2 weeks, but do you, and then they've rented it out for the whole year, but then do you capture that? Because that's where the complaints come from. Do you capture that and, you know, hit them with a provincial fine? I haven't really thought this out in my head. I'm just
Yeah.
going off the cuff here.
And off the cuff, there's a few flags that come up administratively. I think having different fee schedules for different places sounds onerous, a lot like a little bit more staff time. And I think the whole intent of this too is that it is a user pay system, right? So whether you, just in all fairness, whether you rent it for, 4 weeks out of the season or 16, the administrative work to get licensed is the same. For on average, it's the same. So the time spent to do it stated, the way that the bylaws drafted and the way that we see the licensing program kind of unfold, and that largely the responsibility of the owner, same with, the responsible person being called. I don't foresee needing to have some kind of overarching program to track any of this. We don't need like an outside source to monitor who's, because it's going to be largely complaint driven is the way that we see it. So I think the overhead is not going to be as large as, so to me, if you're running a short-term rental for 4 weeks, the fee of $300 would be as significant as $300 for 16 weeks, as long as the rules aren't being broken, right? I think we have to remember the fee isn't necessarily, like, there's a purpose for the fee. The fee doesn't just go into the coffers of the municipality and we just wait for enforcement, right? Like there's a purpose behind it. I'm coming off the train anyway. Okay.
Any other comments? Glenn?
Yeah, so should we put less dollars on registration and more dollars on infractions? Because that's really what we're trying to accomplish, is to get everyone registered, or as many as possible registered, and not be invasive. And yet the infractions are the problems we need to deal with. That's why we're all here as a guiding principle.
Ian?
What's the probability of collecting the fines from the problem people that maybe won't register?
So if the problem people, if they don't register, they'll get a fine of $900. At least that's what it says here. And that's still up for, this is the same value that Blue Water has put on. I put it in here. So if you operate one without a license, the fine is $900, and that's a provincial offenses fine. So that gets registered with the court. So either you pay it or you can contest it and we go to court. That's the penalty of doing that. Administratively, are we going to get $900 back for the effort it took to get there? Probably not. I would argue there would be a few hands in making that happen between the bylaw enforcement officer, myself, between Kelly, there would be, would we get to $900? And then, if they contest it and go to court, well, there's a whole other expense from the municipal standpoint, which isn't necessarily covered by the fees. So there's a happy medium here. Yeah.
But do you get to charge them the $900 for not having a license, but then you also get I'm trying to scroll down to the infractions, but you also get a fine for, what is it? Advertising. You also get a fine for providing false information. Like, do you get all those other fines, or do you
If
put
it's defensible.
other
Right.
offenses in? These are all
Yeah.
provincial offenses, but
Yeah,
do you
exactly.
add other fines, that you can
Yeah.
collect on municipal taxes?
So in terms of administrative fees, so fees are things that we can collect as municipal taxes. Fines are what the province, those are provincial offenses fines. Side note, and before I forget, I just wanted to request if that was an inclusive list for the committee, if there were other things that needed to be addressed as part of a fine or a demerit point. But when it comes to provincial offenses, these fines, what happens is, and there may be changes that come as a result of this, and I'll digress a little bit. When council approves the schedule, this gets sent to the Ministry of Attorney General, and they approve those fines. What they do is they judge the fine based on what others do, and they'll see if it's reasonable. They'll also confirm the offense, so make sure that the language is something that they can actually use in court. So that the language in the bylaw is definitely reflected. So, I mean, it's up to the officer who's issuing the fine. What sections are they contravening? If they're contravening 4 of them, well, then we'll, issue those 4 different ones, give them an order to pay. And then if they pay it, great. And then if we get another complaint and they still haven't registered, well, then we do it again.
I have a comment. I'll call on myself. Okay. The proposed fee discussion. Just listen to what we're saying, and people going under the radar, and we want them to sign in, but they're not really using it that much. And can we do it to the use, but no, it's the same amount of that, and what are the right numbers? I'm just going to reiterate. Okay. When Zares, I know I like to use colloquialisms instead of that language. But when they first came out with that Instacart, those green carts, and you can call and put your order online, it was free. It was free. They're like, try it, it's free. And then after they got everybody hooked on it, now there's a fee. Okay. And I don't think it's revenue neutral anymore. I think they're making money on it. And I still think that if what we really want is people to sign up, then we don't aim for revenue neutral the first year. We didn't get revenue neutral with graveyards. We didn't get it with garbage. It's supposed to be. There's lots of things that are supposed to be, but we all know it costs more to start. If we can have a soft start, that it's the pain is not the money, it's the actual paperwork, but then you're protected in the future of what's coming that might be coming to your area. I think that that's better. What we're looking for is compliance. We want our good guys protected, and they're good guys. We have to show them that if you want to be protected, you have to be part of the system, really. And so, this would be a council decision, but I still think that it could be community betterment. Get that the first year. Hey, the first 3 months you sign up. It's we can't do free apparently, but I mean really cheap, and then it's going to go up to what it actually costs, and come in early and get this done. I know it's a pain, but we really want you to do it, and set the fee schedule based on what it should be, which is going to probably be higher in some areas. Once we have buy-in from our general public, not the general public, the people who need to buy in. Ian, I'm looking at you. Does that make any sense or no?
It makes sense for the ones that are going to go through the hassle of doing it. And from what I see, it will be a hassle. It'll be a very time-consuming initial thing to do. And like you say, the second year won't be near as bad because you're going to have your drawings all done, unless you do anything major. Then you have to have a building permit then. But yeah, the second year would be easy compared to the first year. But I could see spending, if you want drawings that are drawn to any close scale, you're going to spend 10 hours, 15 hours doing it. getting everything together. And if you have to start from scratch and do your policy and your what not to do and what to do and that, it's all very time consuming. Now, if there's if somebody does it and you can take their ideas or template and just plug in your stuff, then that cuts down on everybody else's time substantially. But you can't cookie cut everything either. It's got to be personalized to a certain point. So I think it'd be a very time, and maybe I should go down and from what we've got, just try and see how many hours it does take me or my daughter to do it. So I'm used to delegating, so.
Any other comments? Glenn?
Yeah, thanks, Madam Chair. What do we have in place that if someone is non-compliant, that the activity is ceased until a decision has been made on it? And where I'm going with that is if someone chooses to be non-compliant and they just continue to do it through the whole season, what do we have to prevent that from happening?
We have a court order that says there's an injunction that says you have to stop what you're doing. That would be the ultimate.
I think we're talking about, to me anyway, two different things, or maybe it is two different things. Number one is the buy-in and what's the fee and how are we going to get people to do it? Number two is what are we going to charge them when they don't, or punish the ones who don't care what we say? And that's, I think, two different groups of people. And yeah, Florence, go ahead.
So from staff's perspective, I see this in twofold. There's the cost of just the time it takes to address an application and to issue a license, to review the documents and to issue it. That's to me what the STR fee is about. That's what that's about. Then there's the bylaw enforcement side of it. And that's the piece where you hope to recoup your costs. And that's the separate issue. From an admin standpoint, I think first year free means the taxpayers are paying for the registration of it. That's the reality of that. Which I'm not sure broadly would be an accepted thing. For the most part, user pay systems need to be user pay.
Yeah, we wrestle with that budget every year. I understand it. I would talk though now, I would reference the Port Albert master plan. The people there's some of them who don't want the roads and the drainage because their property's just fine and they don't feel a need for it, but it's for the greater good. It's for the ones who do want use of their properties. And in that instance, the municipality is paying for 100% of the road and 50% of the drain, and they're upset they're paying 50% of the drain because they didn't want the drain. And then I have farmers coming to me saying, why are they yelling? If it was a drain, municipal drain went through my land and I don't care if it's there because my land's just fine, I have to pay 100% of it. So what's going on here? And I'm like, well, it's a juggling act, right? So yeah, the people who are benefiting from these STR rental licenses are not necessarily the people who they're being issued to. It's their neighbors. So to some extent, I do think the general public should pay part of it because it's to protect everyone, not the people who are paying the license. So, and what we want is buy-in. We want buy-in. I mean, if only 50% of the people do this, it's going to cost us longer down the road when people complain and then we have to go through the courts and get them to do it, right? It'd be a lot easier if they did it right from the beginning. I think do something, do it right, and go big or go home because you have to do it right. If you go to a website and it's a bad website, you're never going to look at it again. It doesn't matter how good it is a year later. You're just not going to do it, right? So this has to be right when we do it, and it has to be properly priced, and it has to be easy. and there has to be templates, and there has to be education and help. And that is an onerous price to put on somebody who's doing it right, and we're trying to protect their neighbors, really. I think there has to be some public taxes going to this, and that's how I feel about it, but I'm only one person on council. Anita?
Florence, remind me, did we talk, when we talked about the fee, did we talk about estimating the staff time that would be involved in that? And did we come up with a number, a dollar figure?
As we did. We talked about 2 hours per application. And of course, I went back to my desk and said, why did I say 2 hours? And when we put a dollar value to what it would take, Mark and I had a conversation about it, and we kind of came around a $350 mark is where we came to addressing an application, regardless of what kind of nuances are with it. If you had, I don't have the calculator in front of me, but if you had, say 40 people, 40 owners who voluntarily decided that $350 was worth, following the rules and making sure that they could advertise and, that they're above board and they can let people know that they're licensed and that it's a safe place to be, all those kinds of things, that by the end of the first season, we would have a source of income as well as a list of expenses based on hours and any incidentals or even bylaw enforcement that was as a result of it, that we would have a better picture. I think because we've been dancing around this, we have to set something and try it out, because we don't have, again, every municipality is different. We can't cookie cutter each one because it's so very different. But we have to try something, or else we're not going to know where we're going to land. From an admin perspective, I disagree with free for the first year. I disagree because I don't think that's the intent of this. I think there's value for the community, but there has to be some kind of acknowledgement that, I'm going to sign up this year, but I'm not going to do it next year because it's going to cost $400 next year. I would propose suggesting $350 for an application fee, to apply for a license for a short-term rental, $350. We include that as part of, the recommendation to council. Let them know that that's kind of where it's falling at. Because we talked about 500, that was thought too much. 150 it seemed a bit skinny. And if you do $350, and the whole point of bringing this to council next meeting is to let them know that it's here. And in principle, the rules and regulations are there. They may not be happy with the fee as proposed yet. We could have a look at that, but that's going to get set at a later time as well. So for the purpose of moving things forward, I think we need to set something.
Yeah, Anita?
When I vote on something on council, I like to be able to defend it. So I like the fact that there's data, this is data driven at $350. So I wouldn't have any trouble defending $350 based on what Florence has said. And I'd be willing to support that $350.
Can I ask Mary and Ian to jump in on this, or
350 seems like a lot for the first year. But it is what it is. I think I really disagree with free, because if you offer it free for the first year, you're setting the people up to apply, and the next year they don't like it, then all of a sudden you've got their names and numbers, you can go and inspect them. And so I think that's not the straightforward upfront way of doing it. The first year for the township is going to cost more money to go through the application. Second year, it should be same as what the owners go through. It should be a breeze. It should be a lot less time. So your first year fee is going to be, if your costs are $375 or $350, next year fees are going to be half that. I'm guessing. I have no idea. So what about if there is for the second year, if there is no complaints on that property, that their fees dropped as well? If we had a property and we rent it for, well, rent it for 1 week or 16 weeks, doesn't matter. If we didn't have any complaints or any bylaw infractions, then we're actually paying for the bad guy. We're not, you're not coming to see us, you're not doing anything. So why not give that person a break to decrease their fee? And I think you'd get better buy-in from the good people, the ones that are not the good people, maybe then they're going to be really up in the arms. But
Mike Nicholas.
Mike?
I have a question. And I know there's a wide range depending on the type of cottage that is being rented, but what would the range of rental cost be for 1 week? From where to where? Small cottage to large cottage. What's the weekly rent?
I'm just going by what my sisters say, and it's not gonna, I would say, depending how close you are to the lake, between $750 and $2,500. Are you walking out onto the beach? Is it a bigger one, or are you in like a little shack and you have to drive to the beach? But and 750 is not a nice one. I think you should probably start at 1,000 or 1,200 a week. Kingsbridge is, we just reviewed it, but it has been in the range of $1,200 a week, and you have to drive to the beach, but it's a very large house. So I know my sisters are paying over $1,000 and they're not on the beach. So
So unless it's a real wooden tent, the 350 would be less than a week's rent.
100%, 100%.
Yep. Thank you for that perspective.
Yeah, Ian?
that's great. 350 is less than anybody's weekly rate. We're probably up in the $2,500 a week. But for the guys that are doing it for 2 weeks of the year, that 350 could be a fifth or a tenth of their income. So
Yep, Mary?
If you go online and look at sites, I think anywhere from probably $1,500 to $5,000 a week, depending on the luxury, of the cottage. And, but I also, and I think 350, like, I could do that. I'm a rural, but I would I'm a rural, like, we're part of this community, and we're going to pay whatever the fee is because that's what you do, and there may be a lot of people that don't do that. But I think probably 90% of short-term rental operators are going to comply because, they're part of the community. And Jennifer, I really liked when you talked about it's for the community good, and I don't know if I think there's, 5 or 6 bad actors. Hopefully they're going to get bored, or, their property's going to be devalued or whatever. And we don't want other bad actors to come. And so that's part of the promotion to the community in a way that's going to sell this program, right?
Well, it sounds like we have a consensus of going forward with 350. I do like Ian's suggestion that good actors get rewarded, because you do in other industries. And I don't know if I usually would have ended this at 6, and it's particularly important because I have a wedding in less than 2 days, but this is really important. But it won't go later than 6:30 because I have to go. But we need to put this to bed so we can move forward. But Florence, you have
Sean has a comment first.
on this? Okay.
I just wonder if we're going to make the recommendation to council for $350, could we include in that recommendation that it be reconsidered and something along Ian's idea was considered at this point next year by council, or whenever the fee bylaw is reviewed?
So my suggestion, because I think it seemed well received, we didn't get anybody who knocked against it, that, we'd recommend to council that the first year So when a licensee has their first year, it's $350 for their first year. If they get no complaints, do we drop the fee to say $250? So there's $100 off if you have no complaints. And in that, if you get a complaint in that second year, well, then it goes back up to $350. You know, that kind of,
Or it doubles.
or it doubles.
If you know, like,
Well, let's not get too punitive here. I mean, we try to do our best, but I mean, we've had renters that said we're coming with 4 people. Next thing you know, there's 20 teenagers in there and you're like, that is not who signed these papers, you know, so you can't help the people who lie to you, right? Anyway, Ian?
And certainly from a staff perspective, the renewal of that license is less onerous in year two.
Mhm.
Yes.
Yes. Okay, Evan?
And going back to something that Florence said earlier, the fee pays for the admin. The fines pay for the bylaw enforcement, hopefully. So I'm not sure about the doubling part, just because it's not paying for the bad apples. That admin section, it's supposed to be paying for the office part of it.
Yeah. The
Right?
demerit point system is what's supposed to take care of that, right?
But I like Ian's idea of coming down a bit, because after first year, and it's not the first year of the plan, the first year of enrollment is the 350.
Yeah.
The second year and beyond is 200 or whatever the idea was,
Yeah.
just because the site plan's in and everything else.
This sounds like it's coming together. Okay.
Anita?
I agree. I like Ian's idea of, you know, rewarding the compliant ones. But I wonder if we couldn't just say today that we set it at 350, or recommend to council that we set it at 350. And when we come to the public consultation, that's where we introduce the idea that, oh, but this is something that the committee is thinking of recommending to council, is, you know, benefiting or rewarding compliance, as opposed to putting it in the recommendation to council at this point.
I'm going to suggest that a lot of people are already watching this. Hi, everyone. Yeah, Glenn.
Yeah, what if we were to set the initial fee at 350, and if there are no infractions, the following year would be 250. That is an encouragement to comply. And as we all know, the first year is the most expensive from an admin standpoint. After that, it's less.
I have another suggestion. Do we have to be that specific? Can we say for the first year, we estimate that the cost is going to be 350. We will be reviewing it with the thought that second year will probably be cheaper. But we don't know that 350 is the right number, right? So how do we know that 250 is the right number? Can we recommend that we review it, or, you know?
So my suggestion would be to recommend to council that the first year, literally saying first year, the fee for registration is $350, with the intention of reducing the fee in the second year for compliant behavior or something like that. And then we can address what that value is, you know, after we've had a chance to have the public consult and whatnot. We've got this recorded because I like what I said.
Sean, yeah, or do you just need direction?
Just a show of hands that we agree that 350 is agreeable, and that we'll recommend.
We're intent is to recommend reduction
reduction.
based on our
Yes.
data or in public input.
So that's going to be part of the recommendation to council.
Does
We can
everyone
just-
agree with that? Show of hands? Okay, it's unanimous.
Thank you.
So do we have enough for that?
Yes. Yes, we do.
Okay, so it looks, sorry, it looks like at this point, you have enough that it can come to council for the August 12th meeting. Is that correct?
Yes. Sorry.
Okay, yeah, Anita?
Are we moving to new business? Because I'd like to,
Just about.
okay.
So hang on a second. So Florence, you have everything you need to move this forward to August 12th.
I believe so. We'll have the bylaw in draft form for
With-
council's endorsement. So I'm going to be requesting a motion that council endorse, not approve it, because that's not what we're doing,
Mhm.
that endorse the content of the bylaw, with the expectation, you know, and one of the next clause will be that the short-term rental committee proceed to public consultation. So after August 12th, we can plan to have, you know, an open house or those kinds of things. So
The draft bylaw that has been presented with the amendments that were agreed upon.
yes.
Okay. So do you need a motion for that then?
No, because we, actually, I would just prefer a show of hands that everybody agrees that it's being recommended to council for endorsement.
Okay, for endorsement. Mike, do you agree with that? Morning? Yeah, Mike's here still. You're doing great, Mike. Hang in there. We're almost done. Okay, moving into new business.
Thank
Okay,
you.
Anita?
I'm not sure if it should be under new business, but I'll throw it out there, is that I think it should also be recommended to council that this STR committee, after it has done the work towards the bylaw, meet again, and I'll just put out a date, say October 2026, to review and reflect and possibly make any amendments that might be needed to the bylaw. I don't know if that's under new business
I
or
don't either.
whatever,
Looking
but
up
I
for it.
thought I'd throw it out there because I don't want that to get forgotten somehow. I think it'll be very important for this committee to review this after a year.
I agree. I also, at some point, it's gonna have to get talked about, you know, a composition of an appeals committee as well. The council's gonna have to consider that. From a staff perspective, I would recommend this committee be the appeals committee, just because everybody's so well versed in what it is, and as long as everybody still wants to partake. But that would be the intent there. I believe that after when the term is up of this committee, when the mandate is finished, staff's going to recommend that this committee continue on to do the review pieces and as well act as the appeal. So when I mean, as part of the bylaw too, maybe not a part of the bylaw, but we'll make sure that these reviews happen at least annually.
Go ahead.
Can I just make one point though, with that in mind? 2026 is an election year. And I'm not certain when municipal elections are in 2026. They're generally in, I think, November, but it could be October. Maybe it's October.
The third Monday of October.
Okay, so I think it would be important to keep that in mind when the recommendations go to council.
So I wasn't clear. Was that new business or not?
I think it's just a piece of process that we've got to review. So this kind of is segueing into the next meeting.
Okay, we were not done with new business yet.
All right. I'm going to leave that.
Okay, Mary, you had new business?
I don't know if this is new business either, but just in terms of, you know, introducing this to the community, will this committee have anything to do with that or?
Mhm,
Okay.
a lot.
Okay.
Florence?
So to that, my suggestion for the next meeting of the committee would be to kind of articulate how we're going to hold the open houses, what kind of documentation will be submitted or presented, the expectation of the committee members, you know, to be there to kind of be the face of it. That was kind of my suggestion. Then maybe some other documents that you know, you're looking for, some of the education pieces, maybe. That was where
I think
was
that's a
going.
good idea. Would you have dates suggested? Because if we're trying to get this done before Thanksgiving, or are we? If we're having an open house for seasonal residents, some of them, it needs to be really soon.
So we did have a report that came to the last committee meeting about proposed timeline of that. Kelly, do you mind pulling that up and just having a look?
So I think our timeline was proposed for September 2025. Week 1 would be to launch. So that would be the first week in September. Then commenting period for weeks 1 to 4. Then an open house week 2 to 3. So that would be second or third week in September. And then a council report week 5 and 6.
Sorry, Mike, I'm saying it's a short turnaround from the end of August to the 1st of September. Thoughts, staff?
But I'm of the thought, let's do it. Go ahead, get it done. I mean, those who are sincerely interested, A, are watching, B, will know about it. We've got a notice going out in the tax newsletter advising that this committee is working and that there is going to be a draft presented. I can't exactly remember the wording, but it's going out to all of the ratepayers. I say we get moving on it. So as soon as staff has received direction from council, we can establish more of a refined timeline, and we'll bring that to the next meeting in August. Now,
As part of that,
Oh, sorry. Yeah, I'm just checking dates. I'm not on my phone. Well, I am, but I'm checking dates. Go ahead, Mike.
yeah, as far as once council endorses the bylaw, I realize it's going to go out with all the individual tax notices. But could we recommend that a specific notice be sent to the ACLA so that they can distribute it to their members before the Labor Day weekend?
the Ashfield-Colborne Lakefront Association. Yes, that's the acronym. Yes, we can certainly do that. So, just trying to think of some timeline here. After council gives the go ahead, or after they endorse hopefully they endorse it, then we would get a refined schedule together, let the committee members know of what that schedule looks like, including some open house dates. Okay. And then whether that would be presented at the August 26th meeting or whether that would be sent out by email. Probably by email because it'll be sooner. Like I would rather work the week after council to get that done.
Could you do a doodle poll for dates for the open house?
Well, that's well, I was going to jump in because it originally, I think someone suggested Kingsbridge Center because it's on the lake. So the dates I was looking was when Kingsbridge Center is booked because I have access to that. What day of the week were we thinking of Saturday? Because that kind of makes sense, doesn't it? So the 20th is not available, which is but the 13th or the 27th, but the 20th is not available. Right.
What dates are in Jennifer?
September 20th is not available at Kingsbridge Center. I know that for sure.
I think we should send through a poll to do that, if that's okay. I would like, as I'm sure the majority of the committee members to be there. I think that's important to be held on a Saturday or not Sunday, Saturday. Saturday, okay. So we will have a look at that now.
I can tell you
Sorry, I'm
not
looking at
available
dates.
on the
Go ahead.
13th.
You are or not?
I'm not. I've got a wedding that's.
Is it available on the 6th, Jennifer, or not?
It is. Is that too short of a timeline? Our next meeting is August, what? Like 2 days before or something, or 8 days before?
This is consultation, so it's dialogue. You know, there will be, I would expect some formality to it, but for the most part, do you envision it being sort of one-on-one dialogue with some posters?
Yes.
And some suggested wording for code of conduct and all of that stuff?
Yes.
Yeah. So
I don't foresee this as having an agenda. This would be a come and go for a period of 3 to 4 hours, maybe. And you know, we would have a layman's terms of the bylaw, with maybe a couple of examples of the educational material that we've got so far. And then it would be conversations with those who are interested. I don't think that requires, I mean, aside from preparing the documents and whatnot, from a committee standpoint, I don't think there's a whole lot of prep that would need to be done from the committee. So
Just because I'm looking at the availability, what time of day are you envisioning this? If you did it in the morning, we have a general standing policy that we don't have two events on one day, but if necessary in the morning, we could there's a board meeting next week, we could talk about it, but if you're talking the afternoon, the answer would be no. So what time of day are we talking?
I always function better in the morning. That's
Yep.
me.
Madam Chair, could I
Yep.
suggest 10 a.m. to 12 noon?
It's pretty short, isn't it?
Do you need it longer? Do you need it 9?
9, I would think, wouldn't it? I don't know.
I think 9 to noon would be a reasonable time.
Okay.
9 to noon on,
Do you want me to inquire to see if we can do it
Yes.
in the morning of the 20th
or the 6th.
or the 6th?
I think the 6th, the closer you have to the end of
6th?
the season, I think would be better.
Okay, well, then it should be rentable. The 20th we'd have to make a board exception.
I'll declare that I'm out of town on the 6th.
Okay?
All right,
Coffee and
Yes.
treats.
Yep.
we will make that happen, yes.
Good treats.
Oh, yeah.
Does the 20th work for people or the 13th? We're not all gonna work. Maybe we kind of need to nail this down for Kingsbridge because somebody else might book it too.
I'd say the 20th is probably, looks like the most, I'm unavailable, that I would like to be there. Yeah, the 13th, I'm not available.
Okay. So the 6th or the 20th, I can see if we can get it the 20th. And if not, it would have to be the 6th. Does that sound? Well, because Mike's not here. Right. Yeah.
Doesn't hinge on me.
So rather than me ask if you would just send a request to
Yeah.
Kingsbridge.
Can we send a request to Kingsbridge? Okay, we'll put that. So for the 20, we're going to request the 20th from 9 a.m. to noon.
Right.
We will bring coffee and treats.
A director would have to agree to come and let you in, but I would probably do that.
Okay. So stated, do we need, just throwing it out there, do we need to meet on the 26th?
I would think we have to at least talk about what.
Okay.
I think we should see what we're showing the public before we show the public,
Yeah.
right? And maybe make suggested, no, okay, no, I think we need to do more of this or whatever. Does that sound reasonable? Ian?
If you get me the layman's copy relatively soon,
Mhm.
I'll have our cottage done for what I think is needed for the application.
Okay.
For the next meeting, if you want, we can share that. And
Kelly and I can work on that for sure.
And you'll let us know how long it took. Thank you.
Ian, I think that's a really brave offer.
Yeah.
I'm waiting to get your,
It's his daughter, of
my
course. It's
daughter will bill me for the hours she puts into it.
could you send her over my way?
Okay, so do we know what we're doing the next meeting, which is when? Sorry? It's 26. Yeah, I'm home. Good.
Time.
Can we have it at 4:30? Yes?
Can I make a statement? Are you
Sure.
just feeling this out? I'm actually not going to be here on the 26th.
Okay.
So I'm happy to leave the reins with Kelly and Mark. That's up to, if you want to leave it, I'm fine with that. I'm just going to make the statement that I will not be there for that.
We'll miss your smiling face, but we miss Mark, so
Yeah, there you go.
you just tell him exactly what to say.
Oh yeah, don't
okay?
worry. He'll know what to say.
Is 4 or 4:30 okay instead of 7? Everyone? 4:30? Okay. Okay, so if there's no future new items, the next scheduled meeting of the short-term rental committee is August 26, 2025 at 4:30 or at the call of the chair. Before I ask for adjournment, so if the 20th is available, you're going to let us all know
Yes, as soon as
you know.
As soon as we know, we will have that booked in. And then what we'll do too is we'll also, as part of the council report, let council know that the public open house, should council endorse this, we plan to have the public open house on September 20th at the Kingsbridge Center from 9 till noon.
So just because I don't like to make decisions for the board, if the 20th is not a go, the second alternate date is, because that should go in the letter, because we're making the assumption that,
Can we cross that bridge when we get there? Like, because we'll know tomorrow whether or not we can, right? Maybe?
no,
Okay.
you won't know tomorrow. You would get a verbal okay, but then Jim, who is, everybody's going to a wedding, my kid's wedding at Kingsbridge, but the next meeting is next Monday.
Okay.
So you would know next Tuesday morning. Is
Which-
that still?
That's
enough?
fine. I think council agenda, like we won't have that published until next Friday, so I think
Okay.
we've got some time.
Okay, great.
So we'll go on the 20th and then any changes.
Okay. Can I have a mover and a seconder? Ian and Sean, that the short-term rental committee does now adjourn to meet again on August 26, 2025 at 4:30 PM or at the call of the chair. All in favor of that motion? Motion carries. Thank you, Mike, for staying up for us.
Enjoy,
to
enjoy
correct
your
the time,
time
it-
away. Hope you can get some
Thank you.
sleep.
Yeah, it's 1:26 a.m. actually.
Oh, gosh.
See,